Very edgy panel. Order and Disorder in 18th Century Paris, Stories from the Châtelet Criminal Court. So we have 3 speakers and a comment, and we're going to try to stay on track here so that there's plenty of time for you to pose questions. So our first speaker is Kathryn Norberg, who teaches in the History Department and also in the General Studies Department at UCLA and actually chaired that department. And she was for many years director of the UCLA Center for the Study of Women. She was president of the Western from 2003 to 2004. She also was co-editor of Signs for 5 years at the beginning of this century. And she edited Fashion Print in the Age of Louis XIV, and she co-edited Furnishing the 18th Century with Dina Goodman. Her articles include The Prostitute's Body, Medieval to Modern, Salon as Stage, Actress, Courtesans, and Their Homes in Late 18th Century Paris, and In Her Own Words, An 18th Century Madam Tells Her Story. She's completing a microhistory of a Parisian brothel, which operated from 1749 to 1757. This study is based on a 500-page manuscript produced by the brothel madam, who kept a detailed record of life in her house for the police. And her talk today is called Voices from the Châtelet Court, Seduction, Madams, and Prostitution in 18th Century Paris.
Okay, this panel emerged from discussions among the 3 participants about the Châtelet Court records as a means of hearing the otherwise silenced voices of silenced people. In this spirit, I'll talk about what the court records reveal, what they hide, how they can inform, and also how they can mislead. But I'm going to begin with one and focus on one particular case. That's the case of Louise Moyon, an illiterate maquerelle, or madam, who in 1749 procured a 10-year-old girl for one of her clients. Today, Moyon would probably be considered an accessory to the sexual assault of a minor. 18th century judges, however, despite lots of different nomenclature for this, tended to prosecute this crime as a type of maquerellage that had special circumstances that required unusually harsh punishment. In such trials, the judges preferred victims who were prepubescent or under 12 years of age because they could be presumed to be virgins, their youth precluding the possibility, very real in the judges' minds, that the child was a libertine. Now, using the Y series indexes and a few memoirs, I have located 8 indictments issued by the Châtelet accusing brothel madams of prostituting prepubescent girls. Half were never resolved. That is, the judges decided to plus amplement informer, which I've translated here, thanks to Jeffrey, further inquiry. And the defendant would remain usually imprisoned for either 6 months, a year, or whatever. Usually just 6 months in these cases. All right, of those, half ended in further inquiry, half ended in a conviction. And of these successful prosecutions, 2 were in the 1720s and 2 in the 1750s. Thereafter, this kind of indictment for procuring a minor disappeared, at least from view. Before speculating on why there were so few indictments and why they ceased in the 1760s, let's look at this one particular Moyon case. It illustrates the difficulties adjudicating these sorts of crimes and the degree to which neglected voices are heard in trials. On the morning of August 7th, 1749, Marie Motel, the widow of Michel Bélanger, herself a water carrier domiciled in the Rue des Poulies, lodged a formal complaint with the police commissioner de Mortain. The widow Bélanger explained that her 9-year-old daughter, Marguerite, attended the charity school located in the parish of Saint-Germain-l'Auxerrois. When widow Bélanger went to collect her daughter at noon from school, she could not find her. She searched for her and finally found her about around 3 p.m. crying on the Quai de l'École. The girl told her mother that a demoiselle had fetched her at school and with the help of a boy had put her in a carriage and then taken her to a house very far away. There, another demoiselle offered her wine, beer, and cookies and removed her clothes. These demoiselles then took her to the adjacent room where a man appeared who, quote, wore a sword, a black suit, and pulled his hair back. He caressed the child and told her he would give her new clothes, his gold watch, and a diamond ring that he was wearing. The man continued to caress her body and placed une pièce de chair, her words, in her hand and urged her to stroke it. The girl began to scream, so the man left, giving her, the demoiselle, 3 livres, and the child 3 sols. Once dressed again, Marguerite was put into a carriage and driven to the Quai de l'École, but not before the principal demoiselle had promised the child brioche and petit pain and told her to meet her the next day at Saint-Germain-l'Auxerrois, so that they could take another carriage ride. The next day around 9 a.m., the police commissioner Daumartin was surprised in his cabinet by an angry crowd, demanding that he arrest the young woman that they had taken into the demoiselle that the crowd had taken into custody. The demoiselle had made good on her word. She had returned to pick up Marguerite, but the widow Bélanger and her relatives pounced. Persuaded by the public clamor, always very persuasive for these commissioners, Commissioner Daumartin drew up an arrest warrant and questioned the mysterious demoiselle. All right, she turned out to be Marguerite Moiron, called Victoire, age 20. A widow, she says, a ravaudeuse, and a prostitute. She had been imprisoned as such in 1748. Victoire accused a brothel madam named Moyon of planning the abduction and forcing Victoire to carry it out. She also stated that the assault had taken place in an apartment rented by Moyon on the Rue Fossé-Monsieur-le-Prince. When the police investigated a few days later, Moyon had cleared out. It was not long before they found her and arrested her and the boy messenger that accompanied her. The homes of all the suspects were searched, and on August 9th, the interrogation of the defendants began. For the historian, the interrogation is the most interesting part of most trials. If voices are to be heard, it would be at this time, when the defendants were allowed, indeed encouraged, to speak. But in this case, and in my experience in most interrogations involving prostitutes, the suspects resisted manipulation and kept their responses extremely brief. Moyon claimed the apartment on the Rue des Fossés-Monsieur-le-Prince was an honest business, where men brought their damaged clothing to be mended by the girls who were seen on the premises. Maybe it looked that way. But she said no more. Only the boy messenger Benoit broke down and admitted that he had summoned clients and brought them to Moyon's apartment. A month later, on September 20th, the information or inquest began. The focus of the trial, however, had changed. No longer was the sexual assault of Marguerite the target of the investigation. On August 8th, Marguerite Bélanger had undergone a physical examination by the Châtelet surgeons. No signs of swelling, bruising, or injury appeared on her female parts. She had not, they concluded, been violated. They have a very narrow definition of rape. What about the man in the black suit who had purchased the child? Well, he was still unidentified and at large. The judges issued a subpoena ordering that an unknown man appear to testify. Unsurprisingly, nobody showed up. The police looked no further. By their lights, their job was done. They were there to avoid further scandal, which apprehending this man might have caused, and support the powers that be, especially persons of quality. The case did not move forward for 6 months, suggesting that the judges may have considered abandoning it or rendering a more information verdict. To return to the question that I posed at the beginning of this paper, how do we explain the small number and eventual disappearance of cases against madams? Had the court become more tolerant? Not at all. The police increased arrests of prostitutes, but they did so outside the courts. They used secret warrants known as ordre du roi, or, as you probably heard of them, lettres de cachet. Right, in the registers of these royal warrants, now preserved at the Archives de la Préfecture de Police de Paris, 82 women alone are listed as guilty of running a brothel with scandal. I think that means somebody complained. In the year 1750 alone. So there are many, many prostitutes being arrested, but off the record, if you will, and by these secret warrants that facilitate the work of the police a whole lot. They just arrest them, then they go ask for one, it's granted, and they're in the Salpêtrière right away, or at least Saint-Martin. So, and the number would continue to grow. But the judges chose not to use a royal order in the case of Moyon and her co-defendants. So back to the case. In 1750, after ignoring the case for months, the magistrate suddenly issued a verdict. Why? What had happened? Well, in May 1750, a riot erupted in Paris, which led to the death of one policeman and the injury of more. The police chief himself had to flee in the night to escape an angry mob. The violence had been precipitated by rumors that the police were abducting children. Now, the similarity between that rumor and the charges in the Moyon case, I think, are clear, right, about child. Well, Barbier, the lawyer Barbier, did not miss them himself, and I don't think many other people did. The case offered an opportunity for the judges and the police to reassert their control and their role as protectors of families, and do so publicly. The judges publicized their decision by having the Parlement sentence printed and posted on walls and then cried out in public around the Châtelet. The judges also prescribed in detail the punishment to be inflicted upon Moyon, Victoire, and Benoit. They were to be whipped and branded with a fleur-de-lis in front of the Châtelet, common to all kinds of different infractions like theft. But this has, as you'll see in a minute, has elements of shame in it as well. Then with signs hung round their necks reading public procurer and wearing straw hats, they were marched through the streets. Moyon on a donkey facing backwards, I think holding the tail of the donkey. All right, the spectacle drew a huge crowd which jeered and yelled as insults as the cortege passed. The people were much amused, says Barbier. And an image was created which actually memorializes this particular event. When the cortege reached the Porte Saint-Michel, Moyon was thrown into a carriage and driven out of Paris and vanished from history, i.e. I can't find her any place else. I don't know. But what have we learned from her story? First, that the judges, seemingly so aloof with all the secrecy of the procedure, did care what the public thought of them, especially after May 1750. They used the Moyon case to demonstrate that they were doing their job. They were protecting families, punishing criminals. The donkey ride was a public relations coup. Prints were struck of this event and similar punishments. Oop, I put the wrong way. There's one. Okay, but I'm going to go back. I have several others, but let's go back to that one. Barbier celebrated the spectacle. Quote, "This example is important because girls of the common people have no protection and they go alone through the streets and to catechism." The Moyon case could also support several misrepresentations of commercial sex in the 18th century. One might assume that most women were recruited into prostitution by madams lurking around churches and schools where they trapped native girls. It's a trope that has a pretty long history, especially towards the end of the 18th century in literature. In reality, a madam did not need to leave the house to acquire new girls. I know this from my other project on the madam. They came to her. A stream of candidates showed up regularly at the brothel door, brought there by their mothers, fathers, boyfriends, or other young girls. This was very common. One might also assume that the judges were the champion of children whose innocence they sought to protect. This was not their way of thinking. All right, they did not consider children inherently innocent. In another case prosecuted in 1752, the judges described a 14-year-old girl as very corrupt, very libertine, and an experienced whore. The Châtelet officers regularly arrested and imprisoned children for petty theft. After all, Benoit, the messenger, who I believe is this person over here, was in fact only 15 when he was beaten and branded. The Châtelet judges did not defend children, they defended families. They regarded seduction by a madam the same way they regarded rape. It was a crime against a family, not an assault on an individual. Conversely, when a parent offered his or her child to a madam, a surprisingly common practice, the police just looked the other way. A few parents lived openly on their daughters' earnings from prostitution. But only twice, in 1722 and again in 1750, did the police arrest parents for trying to sell their daughters. They're two particularly flagrant examples. In the end, the Châtelet court records tell us more about the attitudes of the judges than anything else. But they cannot answer the question I posed earlier. Why did the punishments, as well as the trials that engendered them, stop? Given how well the spectacle of the donkey ride played, and for some time there afterwards, you have to wonder why they abandoned it. Well, the donkey ride was basically forgotten after 1760, and nothing was written about it, at least that I've been able to find, except for a brief description in the Tableau de Paris. Writing in 1783, Mercier claimed that he had witnessed the punishment himself years before, most likely in 1760 when he was barely 20 years old. And he retained a vivid memory and a very sharp opinion of it. No apologist for prostitution, Mercier nonetheless rejects the donkey ride for 4 reasons. It creates scandal, it excites the crowd, it fuels lubricity. I'm not sure how, but anyhow. Because the madam is whipped torse nu, okay? And it is useless. The spectacle, Mercier says, is filthy and indecent. The procession awakens the vilest urges in the populace and licenses them to proffer the dirtiest and most scandalous words, which shock chaste ears and scandalize innocent girls. So far, Mercier's critique seems rather predictable, but he also attacks the judiciary on the basis of utility. Quote, "This exemplary punishment is supposed to punish women who get rich by seducing girls from good families, or so the naive jurist says. The punishment is useless because the court inflicts it on miserable, shameless creatures who just want to give a hand to an indigent girl." Now, I don't know if the judges of the Châtelet did or did not agree with everything Mercier said. I think they probably agreed with the first part, that it was too scandalous to be held. But if they shared some of his views, it helps explain why the indictments against madams who prostituted children and the subsequent donkey ride disappeared.